Article 22 provides for preventive detention laws. The object of preventive detention is to prevent a person from committing a crime and not to punish him, as is done under punitive detention. Preventive detention is considered undemocratic in a democratic constitution, but this provision is necessary for a new nation in order to save it from different types of dangers to unity and integrity. Since it is a draconian measure, the Constitution, though makes a provision for it, also incorporates certain constitutional safeguards. Clauses 4 to Clause 7 of Article 22 provides the following safeguards to a person detained under preventive detention laws. Number 1. Ground of detention must be communicated. Article 22, Clause 5 gives the right to the detainee to be communicated the grounds of detention as soon as possible. The detaining authority making the order of detention must as soon as possible communicate to the person detained the grounds of his arrest and to give the detainee the earliest opportunity of making representation against the order of the detention. The ground of detention must be very clear and easily understandable by the detainee. The ground of detention must be in existence at the time of making the order. No part of it can be held back, nor can new ground be added thereto. State of Bombay versus Atma Ram AIR 1954, SC 157. Unexplained delay in considering the representation under Section 8 of NSA by detaining authority will make the detention order invalid. It was held in Abdul Aziz versus Delhi Administration AIR 1981, SC 1389. In Ram Bahadur vs. State of Bihar, AIR 1975, SC 245, it has been held that where the order of detention is founded on distinct and separate grounds, if any of the grounds is vague or irrelevant, the entire order must fail. Number 2. The right of representation. Article 22 imposes an obligation upon the government to afford the detainee the opportunity to make representation under Clause 5. It makes no distinction between the order of detention for only 2 months or less and those for a long duration. The obligation applies to both kinds of orders. It does not say that the representation will be considered by the appropriate government in the former class of cases and by the board in the latter class of cases. It is clear from clause 4 and 5 of Article 22 that there is a dual obligation on the appropriate government and dual right in favor of a detainee, namely, number 1, to have his representation irrespective of the length of detention considered by appropriate government, and number 2, to have once again in the light of the circumstances of the case considered by the board before it gives its opinion. If in the light of the representation the board finds that there is no sufficient cause for detention, the government has to revoke the order of detention and set a liberty to the detainee where the detaining authority commits delay in considering the representation, the detention order will become illegal. Thus, whereas the government considers a representation to ascertain whether the order is in conformity with its power under a relevant law, the board considered with representation from the point of view of arriving at its opinion whether there is a sufficient cause for detention. The obligation of the appropriate government affords the detainee opportunity to make representation which is distinct from the government's obligation to constitute a board and to communicate the representation amongst other materials to enable it to form its opinion. The above conclusion is strengthened by the Preventive Detention Act 1950, made in conformity with clause 4 and 5 of the Article 22. Consequently, the detainee has a constitutional right, and there is on the government a corresponding constitutional obligation to consider his representation irrespective of whether the representation is made before or after his case is referred to the advisory board. Pankaj Kumar vs. State of West Bengal, EIR 1970, Supreme Court 97. Number 2. Advisory Board. Article 22 provides that the detainee under the preventive detention law shall have the right to have his representation against his detention reviewed by an advisory board. If the advisory board reports that the detention is not justified, the detainee must be released forthwith. If the advisory board reports that the detention is justified, the government may fix the period for the detention. The 44th Amendment Act 1978 has amended Article 22 and reduced the maximum period for which a person may be detained without obtaining the opinion of the advisory board from 3 months to 2 months. And it has also changed the constitution of the board, which shall now consist of a chairman and 2 other members. The chairman must be a sitting judge of the appropriate high court, and other members shall either sitting for or retired judges of a high court. The detainee has no right of legal assistance in the proceeding before the advisory board, but if the government is given such a facility, it should equally be provided to the detainee. The discretion of the board to permit or not to permit must be exercised in conformity with Article 14 and Article 21 of the Constitution. That is, it must not be exercised arbitrarily. Nandlal versus State of Punjab, AIR 1981, Supreme Court 2041. In ADM Jabalpur versus SS Sukla, AIR 1976, SC 1207, the Supreme Court has held that when an emergency is declared and the right to enforce fundamental right under Article 21 is suspended, no person had right to go to court for challenging the validity of his detention. The effect of decision is that a court would not be empowered to examine the question of mala fide on grounds of the order of detention. In Makhan Singh versus State of Punjab, AIR 1964, Supreme Court 381, it had ruled that it could examine the validity of the detention on the ground that the order was passed with malice and there was excessive delegation of power of the provision of emergency law were not followed. The court, however, held that Makhan Singh's case did not apply in this case. The 44th Amendment now provides that Article 21 will not be suspended during emergency and hence detention can be challenged in the court of law. So that's all about detention. If you find it useful, like, subscribe my YouTube channel.